morning. We're going to start the meeting. And our scheduled business this morning will start by voting on the draft September 2019 board meeting minutes, which board members have received and are posted on the board's website. Will a board member move for a vote to approve the minutes? Are there any edits or comments? Then shall we have a vote? Mr. Regan?
Yes.
Dr. Safier? Mr. Perino?
Yes.
Tino? Mr. Hernandez? Dr. Cohn?
Yes.
Ms. Jones-Austin? And I vote yes. The minutes are approved. Before we begin our agenda for today, I want to express the board's sadness to hear about the death of Correction Officer Hippolyte. We send our condolences to Officer Hippolyte's family, friends, and his colleagues at the Board of Correction. I would also like to acknowledge the city's work to significantly reduce the jail population and ultimately close Rikers Island. Since its inception, the board has advocated for alternatives to incarceration and decreases in the jail census. The city's jail population is around 7,200 people today, with a plan to reduce the population to 3,300. In 1991, the average population was 21,700 people. The board applauds our colleagues inside and outside of local and state government who have contributed to this historic and long overdue decarceration effort. Additionally, since the 1970s, in reports and public meetings, the board has stated that the Rikers Island infrastructure and its isolated location creates major barriers to compliance with the board's minimum standards, including access to health and mental health care, connections to the community via visiting, and access to courts and legal counsel. The physical structures of the current borough-based facilities also pose serious barriers to compliance. Ultimately, all jails and prisons need strong, independent oversight. Whether on Rikers Island or in the boroughs, whether in existing jails or new ones, the Board of Correction will continue its mission to document and report on conditions inside the jails and engage stakeholders in improving those conditions for people in custody and staff. Before we begin our public comment period this morning, we will briefly discuss the status of the restrictive housing rulemaking. We had hoped to vote to commence the formal City Administrative Procedure Act process today, but despite the significant efforts of many, we have not yet completed the certification process. We are committed to resolving any outstanding issues and scheduling a special public meeting to vote on the proposed rules for the morning of Thursday, October 31st. We'll post details about the meeting on our website as soon as available. This vote will begin the official public comment period and the holding of a public hearing on the proposed rules. While the rules have not been published in advance of formal certification, we believed it was important to provide an overview of key provisions. To that end, Michelle will now present a summary of the draft proposed rules.
Before we begin, I just want to start by saying that as someone who's been personally involved with rulemaking from day one, a little over 3 years ago, It just is absolutely wonderful that I can present, and the board can present a summary of these proposed rules to you. So I'll begin with what are we proposing? Bennett? Okay. The Board of Correction is proposing a new Chapter 6 of its minimum standards, which is designed to ensure that people in the Department of Corrections custody, 1, are placed in restrictive housing in accordance with due process and procedural justice principles, and 2, are confined in the least restrictive setting and for the least amount of time necessary to address the specific reasons for their placement and to ensure their own safety as well as the safety of staff and other people in custody. Okay. So let me tell you a little bit about the development of the proposed rules over the past 3 years or so. So beginning with groundbreaking reforms in 2014 through 2018, such as the elimination of punitive segregation for young adults and the limitations on the use of punitive segregation for adults, these reforms led to the department's development of alternatives to punitive segregation and alternative strategies to manage its young adult population. Implementation of these reforms required the department to seek variances from our minimum standards and led to the board's imposition of conditions on granting them. The proposed rules provide a comprehensive approach to restrictive housing and eliminate the need for 6 long-standing variances with a total of 30 separate conditions. It all began actually in 2016 when former board member Judge Brian Hamill made a motion at a board meeting to commence restrictive housing rulemaking. The board unanimously voted to approve the resolution, and so the rulemaking began. It didn't begin in 2016 because we were in the middle of enacting our PREA minimum standards. And once they were enacted at the end of 2016, we got to business on proposed restrictive housing rules at the beginning of 2017. In 2017, the board's ad hoc rulemaking committee on restrictive housing engaged in extensive fact-finding on rulemaking. This included discussions with 30 organizations and individuals: the local defense bar, criminal justice advocates, national criminal justice organizations and oversight entities, COBA, correctional experts and academics, and of course our city partners, the Department of Correction and Correctional Health Services, or CHS. This comprehensive effort also entailed a literature review, an examination of department directives, policies, and reports, board staff research, analyses and reports, model restrictive housing standards at the national and international level, and model restrictive housing in jails and prisons nationwide. During 2018 and 2019, the Rulemaking Committee mapped out the scope of the rules. We then prepared a detailed outline of the rules and Chapter 6 drafts of the rules and shared them with the department and CHS. And finally, we engaged in extensive negotiations with the department and CHS on the scope of the rules. I want to just stop here for a moment for a thank you pause. I want to thank all of the former and present members of the Rulemaking Committee. We started with former board chair Derek Cephas, Dr. Bobby Cohn, Judge Brian Hamill, and Jennifer Jones Austin. I want to thank them for all of their incredible support and hard work to get these rules done. I also want to give a very special thank you to our interim chair, Jackie Sherman, who, although was appointed chair relatively late in the process, has proved to be an incredibly quick study and has since dedicated many evenings, weekends, to our rulemaking efforts and other business of the board, all while managing a full-time job. So thank you very much, Jackie. It's really greatly appreciated and a great pleasure to work with you. I also want to thank, at this pause, the department and CHS. Simply put, we could not have done this without you. You are in the trenches day in and day out, and we thank you for taking the time and patience to present your operational concerns to us, and we have listened to and carefully considered your concerns as part of the rulemaking process. So what's in the proposed rules? Well, most importantly, the rules present a comprehensive approach to restrictive housing. They apply to disciplinary housing, such as punitive segregation 1, which is 20-hour daily lock-in. The restrictive housing unit, which is punitive segregation for certain people with mental health issues. And punitive segregation 2, which is punitive segregation with 7-hour daily lockout. The proposed rules apply to what we call in the proposed chapter transitional and administrative housing. Examples of this type of housing are ESH, the secure unit, true, and second chance. The last 3 are all for young adults. And finally, the proposed rules apply to what we call in the proposed chapter structurally restrictive housing. This is housing by its very physical structure, limits a person can find there to engage only with 1 or 2 other people in custody. The proposed rules apply not only to these types of existing restrictive housing, but similar types of existing housing that may be developed in the future. The proposed rules standardize across all restrictive housing types procedural due process protections regarding placement. This includes written notice of placement or an infraction in the case of disciplinary housing, a hearing, a written determination, and a right to appeal. They also standardize placement criteria, exit criteria, individualized behavior and programming plans, periodic reviews, and data reporting to ensure compliance. I'm now going to tell you a bit about some of the key highlights in the proposed Chapter 6. 1, the proposed rules reduce the 30-day punitive segregation sentence to 15 days. The proposed rule keeps in place the 60-day punitive segregation sentence for serious assaults on staff, but we have modified it to permit people sentenced to more than 15 days to earn time off for good behavior. Finally, we've expanded exclusions from punitive segregation 1 to include people who are diagnosed with an intellectual disability and pregnant persons within 8 weeks of pregnancy outcome or are caring for a child in the department's nursery program. Additionally, the proposed rules eliminate the automatic surcharge for guilty infractions. They also call for the placement of people in punitive segregation within 30 days of adjudication. A word about this. At any given time, many people in custody are on a waiting list to serve their sentence in punitive segregation. This proposed rule requires that people in custody be placed in punitive segregation within 30 days of their guilty finding, or else the department may not place them there at a later time. This is consistent with a major tenet of procedural justice that punishment must be swift, certain, and fair. The proposed rules also call for the department to provide the board with a disciplinary system plan for young adults that is consistent, that must be consistent with the Nunez consent judgment, since that judgment is a court order and it requires the department to develop such a plan. And also that it is shared with the board only after the Nunez monitor has approved the plan. Additional highlights: the proposed rules increase young adults out of cell time in transitional administrative housing from at least 7 to at least 10 hours a day. The rules call for elimination of non-individualized use of restraints, such as restraint desks, during lockout in all facility housing units by 2022. Until then, the department will provide weekly periodic reviews of all people who are confined in the most restrictive form of transitional administrative housing in restraint desks during out-of-cell time. Until then, there will also be a rebuttable presumption of advancement out of restraint desks unless the person has engaged in disruptive, violent, or aggressive behavior in the previous 7 days, or there is credible intelligence that the person may engage in violence in a less restrictive level or housing unit. Finally, the public release of the proposed rules will include a statement of basis and purpose, which is a comprehensive and detailed discussion of the basis and purpose underlying each of the proposed rules in the new Chapter 6. I'd like to end with another set of thank yous. I want to thank each and every member of the board who brought to the rulemaking process the incredible breadth of their collective expertise and life experience. And I also want to thank the wonderful board staff, all 26 of them, who are the eyes and the ears and the heart and the soul of the board's work, and whose tireless work informs each and every one of these proposed rules.
Thank you, Michelle, and I would like to echo all of those kind words for everyone who has played such a role in getting us to where we are today. And now I believe the Commissioner Brand, would you like to address us? Good morning, Commissioner.
Good morning, and thank you for the opportunity to address the board on 2 important matters. The formal rulemaking process that builds upon the immense progress this city has already made to reduce the use and impact of punitive segregation, and the vote to close Rikers Island and replace it with 4 new state-of-the-art jail facilities within the boroughs. This department has been a national leader in reducing the use of punitive segregation. Today, we have approximately 80% fewer people in punitive segregation than we did 5 years ago. We have eliminated its use for the seriously mentally ill and young adults. And consistent with state regulations, we now ensure that anyone in punitive segregation has at least 4 hours out of their cell. We know that the board has been working hard on new rules for restrictive housing, which the department welcomes. I understand that the draft rule is still being finalized, and I look forward to beginning the formal CAPA process rulemaking. While the particulars of some details in these proposed rules must continue to be discussed, I am pleased with some key points that we expect to be included. Eliminating the automatic $25 imposed on guilty infractions, further limiting a person in custody's PSEG sentence length for most offenses, while maintaining a maximum of 60 days for cases of serious assaults against staff. Increasing the frequency of reviews of persons adjudicated to the most restrictive level of ESH, potentially reducing the time a person spends in a program desk. changes to the use of programs desk during lockout in all facility housing units, and additional levels of review and support for due process around restrictive housing placements. These reforms are important and fair and will ensure that any person who commits a serious infraction is provided with an appropriate consequence with the least restriction possible while still maintaining overall safety. The safety of every person working and living in our facilities remains my ultimate concern, and I look forward to working with the board to finalize these rules. I want to thank the tremendous effort of the DOC legal and intergovernmental divisions who have worked tirelessly for the past 7 months in their analysis of these proposed rules and their impact on the agency. Finally, I want to take a moment to acknowledge last week's momentous vote to close Rikers Island and build state-of-the-art borough-based facilities. The department has been and continues to be fully supportive of the borough-based jail plan. New Yorkers, the staff of this department, and any person placed in our custody deserve better than our old and outdated jails. Although the closures of Rikers was made possible through projected decrease of the population in custody, I want to again reassure all of our staff that layoffs are not a part of this plan. I truly believe the Council's actions was possible in part thanks to the dedication, commitment, and courage of DOC personnel, both uniform and non-uniform staff, who have embraced not only the spirit, but also the hard work of culture change and reform, and who have helped to turn this agency around. I was taught that your past does not determine who you are. Therefore, DOC will not give the past the power to define our future. There is still more work to do, but I want to personally thank every member of DOC for their commitment to change and the work that they have already accomplished. Members of the board, thank you for your time, and I look forward to continuing to collaborate with you on the work ahead. Thank you.
Thank you very much, Commissioner, and we look forward to continuing to work with you and your team as we move forward into the formal CAPA process. Thank you all. We're now going to move into the first public comment period of our meeting, and this comment period is on the variance request. So we will now hear comment on the department's requested variance that would allow the department to place people into separation status after a positive body scan, or if they refuse a body scan. Body scanners are a new security tool that the department is using to detect contraband. We ask that speakers limit their comments to the proposed variance and to 3 minutes. And first I'll call Councilmember Reynoso. Good morning, Council Member.
Good morning. Thank you for having me here today. I just want to do 2 things before I start my statement. Is just want to recognize the independence of this board in the work that you do, and that be extremely important in what we're talking about here today, and your ability to really affect change in a meaningful way for many people, specifically incarcerated folks that are currently in solitary confinement. The second thing is being very mindful that what vote and what work you do here today and in the coming weeks, it not be just a stopgap or a delay to the justice that we will see when we remove solitary confinement in the city of New York, and the place in history that is going to be written about who in this board made that determination. Just really want for folks to take a step back and think about their place, their legacy, when we talk about solitary confinement, and what I think is going to happen in the next couple of weeks, and how I don't necessarily think it's going to be something that's going to be looked upon positively. Good morning to the members of the board. My name is Antonio Reynoso. I'm a council member of the 34th District, representing Williamsburg and Bushwick in Brooklyn and Ridgewood in Queens. I am also a member of the council's Progressive Caucus, was a former co-chair, and alongside the Women's Caucus came out this year in support of ending solitary confinement and extreme isolation as a form of punishment. It is my belief that solitary confinement constitutes cruel and unusual punishment and is unconstitutional. To put a finer point on it, solitary confinement is a torturous and barbaric practice that can cause irreparable psychological harm and should have been resigned to the dustbin of history a long time ago. I want to thank the Halt Solitary and Jails Action Coalitions for the work in putting together a blueprint to end the practice of solitary confinement and add some points to the conversation. One of the most problematic issues is the solitary or punitive segregation, as it is known by DOC, can take a number of different forms that don't technically fall under this header. This is concerning when one considers that isolation practices are not technically considered punitive segregation and are subject to no clear oversight and accountability measures. To address these issues, I'm endorsing the Coalition's recommendation that minimum standards be applied to all detainees across the board. This includes 14 hours of out-of-cell time for every detainee in city jails and removing any exceptions to standards for punitive segregation, enhanced supervision housing or supervised housing, and other forms of restrictive housing. I'm aware that DOC personnel have raised concerns about officer safety, and I want to be clear, we do not want to do anything that would jeopardize the safety of our correction officers. However, placing detainees in solitary confinement only serves to worsen the conditions that led to this destructive behavior in the first place. We must distinguish between delivering consequences and falling into outright vindictiveness against our incarcerated brothers and sisters. It is critical that we implement programming that gets to the root causes of this violent behavior, rather than reinforcing a system that simply perpetuates it. New York City must be a leader on criminal justice reform. Cook County Jails has already ended solitary confinement. There's no reason that we can as well. I urge the board to restrict the use of punitive segregation to the greatest extent possible, and I hope the next time I have the opportunity to testify, which will be in a couple of weeks, before you, we are talking about eliminating this practice entirely. So thank you for your time.
Thank you very much, Council Member. Kayla Simpson. The public comment is formally on the variance request. Good morning.
Good morning. Ms. Simpson's going to be talking about the other request. I'm Mary Lynn Rowas of the Prisoners' Rights Project. We strongly urge this board to deny the variance requests. If you haven't visited GRVC 2B, which is where the city has created possibly its most medieval jail setting yet, you should, because coming on the heels of the city council vote last week, the hypocrisy is astounding. In the Prisoner Rights Project's long history with the city jails, we haven't seen the board sanction a policy like this. Mayor de Blasio and the city want to allow the government to lock individuals in a tiny cell with a single bed, a toilet that it's not clear whether it actually flushes feces, no toothpaste, no soap, no hygiene items. Ask them about menstrual supplies. They don't say anything about that. And verify the answer, please. No legal materials, even as you're facing your criminal charges. No newspapers, nothing to read or write. Banned from writing a letter. That's one of the variance requests, that you cannot write a letter to communicate to the outside what is happening to you. Banned from recreation, even though human bodies need to move to function. Banned from visiting your family, even non-contact visits. And no process by which to object to how you're being treated by your jailers. And this is a least restrictive setting, by the way, according to the variance request. Just like the least restrictive settings you're going to finally tell us about on Halloween. This is culture change. This is what the mayor wants to replicate in the 4 boroughs. This is the future and good government. We are living in the upside down when we sanction this new low in the same room and in the same meeting, we talk about culture change. Quite frankly, the cynicism of this variance request should offend anyone who believes in government as a power for good, in the legitimacy of oversight institutions. How is anyone to believe that there is humane incarceration? A question that is up for debate in our city this very week, when this is what our city hall is advocating and fighting very hard and closed doors for. Virtually no constraints on what it does to people, albeit arguably for a short amount of time, but you can do a lot of harm to a human being in a short amount of time. And how does this board salvage its legitimacy, especially after all the shenanigans that are going on with this rulemaking process, if it sanctions these kinds of variances? They read very dry, they're very bureaucratic. It's probably hard to picture the human impact of what happens in them. But culture change isn't what happens with diagrams. It's not what happens with just parroting the good progressive buzzwords of the moment about your program space. It's what happens behind the closed doors. And only you all have access behind those closed doors. We don't. The incarcerated people are there, but you want to approve a variance that says they couldn't even write a letter telling us what happens from that space. The culture change has to happen now. It happens with what we do in this room. Frankly, it's deciding right here and right now whether there are dungeons in New York City, and I'm not using that term facetiously. Go to GRBC 2B, look at what's happening in the separation status conditions, and see for yourself. The department should be ashamed for seeking these variances, and this board should be ashamed if it grants them. Thank you.
Thank you. Danielle Gerard. Good morning.
Good morning. My name's Danielle Gerard. Good morning, Interim Chair Sherman, board members, and Ms. Oversee. Since 1995, Children's Rights has been a national advocate for youth in state systems. We are also a member of the Department of Corrections Adolescent and Young Adult Advisory Board and the New York Jails Action Coalition. Our experience with adolescents and young adults in foster care and juvenile justice systems often brings us in contact with young adult and youth corrections policy, as our clients are disproportionately represented in young adult and juvenile correction facilities. We are concerned about the welfare of young adults and youth in the custody of the Department of Correction. Given Children's Rights' prior testimony to this board, we ask that the board implement comprehensive rules for restrictive housing instead of granting the department's repeated requests for variances from minimum standards. This rulemaking should incorporate the young adult plan, which recognizes that young adults are inherently different from adults and much more like 16 to 18-year-olds. Today, you will vote on several variance requests regarding a recently implemented form of punitive segregation, separation status housing. The variance request does not include any mention of young adults. It does not include any due process provisions, and it does not include any specific timeframes regarding how long an incarcerated person can be held in separation status housing. Children's Rights is particularly concerned regarding the treatment of young adults in separation status housing, as our senior policy analyst, Alyssa Glucksman-Hein, explained in last week's Jails Action Coalition meeting with Interim Chair Sherman. Brain research shows that placing young adults in restrictive housing can cause significant neurological damage at their important developmental stage. We also know that young adults placed in restrictive housing have issues accessing education and daily programming. They lack interactions with peers and other adults in their lives, which also causes them harm. Children's Rights urges the board to deny the department's variance request. Instead, we urge the board to vote to publish the full draft comprehensive restrictive housing rules for public comment, we urge the board to expand reform efforts to fully realize the goals of the young adult plan. And I'd like to note, in addition to my written testimony, that in December 2014, we submitted a public comment regarding young adults, and we'll be submitting that again because we note that there are many new members of the board who may not be familiar with those rules. But in any event, we strongly urge that the full draft of the restrictive housing rulemaking be published and not just excerpts. Thank you.
Thank you. Jennifer Parrish.
Good morning.
Good morning.
Once again, the board is taking up the department's request to keep some people in 24-hour lockdown, expanding the use of solitary while not moving forward with restrictive housing rulemaking to reduce the practice of solitary and the use of isolation and other inhumane restrictions throughout the jails. The variance request for separation status before you today does not address any of the deficiencies I identified in my comments at the last board meeting, so I'm going to focus my time on the board's failure to move forward with rulemaking. Since the board initiated rulemaking, you have repeatedly assured us that whatever disturbing practices you were permitting through granting variances would be addressed through rulemaking, including the department's invention of solitary units at West facility, which are completely unregulated, and now this separation status housing. The board recognized that many people are affected by restrictive housing. As of April 2018, there were 47 different restrictive housing units with approximately 450 people in these units, with an array of restrictions from out-of-cell time to visits, showers, and recreation. But the board continued to delay in its rulemaking. Finally, in July 2019, the chair noted that the city council members and advocates were calling on the board to make changes to the minimum standards after the tragic death of Layleen Polanco. And you said that much of the input the board has received is broadly consistent with the board's draft rules on restrictive housing. You announced that draft proposed rules had been shared with the Department of Correctional Health, and that by the end of July, you anticipated ending your discussions with the Department of Corrections about these draft rules. Yet here we are at the end of October with no restrictive housing rulemaking beginning, and with advocates and the public still in the dark about the details of those proposed rules. And apparently it's not because the board has been slow to act, but the mayor's office has inserted itself into this process, apparently to stall the change that the board is attempting to require. Board member Hamill, an active member of the rulemaking committee, has been removed from the board. The law department continues to refuse to certify the current draft of the rules. And with no draft shared publicly, we can only assume that the issue is not with the legality of the proposed rule, which is the reason for the law department's involvement, but is yet another tactic to delay the process, allowing more time for the administration to pressure the board to change the rule to accommodate the department's wishes. The board must assert its independence and provide transparency regarding the process by posting the draft rules sent to the law department. You might try to assure us that we will have a chance to review the rule and comment once the CAPA process begins. However, we will not know what compromises were extracted by the mayor, how the rule was changed from what this board agreed should be the starting point for the rulemaking process, and what is ultimately promulgated. The department has had years to negotiate in secret with the board. Once that process ended and the board settled on a draft rule, the mayor's office should not be allowed to continue its campaign on behalf of the department to weaken the rule we start with through removing board members and slowing down the process. Please assert your independence and share with the public what the board sent to the law department to certify. If it turns out that the rule that it certifies is different from the draft, at least we will know what changes were made. Trust in this board to have a fair process will only be strengthened by full transparency. Your integrity is at stake. Anything less can only lead us to think that the board has been co-opted by the administration. Thank you.
Thank you. I'll now call Deputy Public Advocate Rama Isa Ibrahim. Good morning.
Morning, everyone. My name is Rama Isa Ibrahim, and I am the Deputy Public Advocate for Justice, Health Equity, and Safety for Public Advocate Jumani D. Williams. Our office serves as a direct link between New Yorkers and their government and functions as a watchdog to ensure that city agencies are as efficient and effective as the people of New York deserves, including those who are housed in the Department of Correction facilities. Before I get into my remarks, I want to applaud the work this board has done to ensure the safety and protection for incarcerated New Yorkers. I must also acknowledge that we can all do more to alleviate and drastically reduce rates of violence in DOC facilities. Restrictive housing, punitive segregation, separation status, whatever we call it, solitary confinement is an inhumane and torturous way to address behavioral problems in DOC facilities. We must end solitary confinement in the city of New York now. Solitary confinement is a cruel and unusual punishment that causes deep and permanent psychological, physical, and social harm. As a disciplinary practice, it is ineffective, counterproductive, and unsafe because it fails to address the underlying causes of problematic behavior. The scope of this outdated practice greatly concerns me. Per the DOC's most recent report, 117 New Yorkers are housed in punitive segregation units, and there's a backlog of 815 people waiting to be held in these units. Given the size of this backlog and subsequent delay in this population actually being moved to punitive segregation units, it is clear that the practice as a whole is not rooted in upholding safety. If those exhibiting behavioral issues receive therapy services, rehabilitating programs, and restorative justice interventions, the DOC would be better equipped to address violent conduct and minimize conflicts between peers and/or correctional officers. Additionally, it is clear to me that solitary confinement endangers the health and safety of incarcerated New Yorkers. I am still disheartened at the tragic death of Lyanne Polanco, a transgender woman of color with a documented medical history who died in the city's custody on the 9th day of her solitary confinement sentence. I want to clearly state that her death was avoidable, and it is a clear example of why this practice cannot continue. Not only does solitary confinement increase the risk of incarcerated people developing physical and mental health conditions, but it also exacerbates existing conditions, placing New Yorkers at unacceptable risk. I'm also concerned about reports regarding the usage of substitution jurisdiction orders to circumvent New York City's landmark ban of solitary confinement for youth under 22 years old. According to the New York Times report, at least 10 young incarcerated people under the age of 22 has been transferred from DOC facilities to correctional facilities outside of New York City where this ban is not in place. The report states at least 8 young New York City residents have been placed in solitary confinement in the Albany County Correctional Facility. This loophole must end, as no New Yorkers, especially our youth, should ever experience solitary confinement. Lastly, I would like to express my concern regarding the DOC's use of so-called separation status on incarcerated people after a positive or refused body scan. While ensuring that contraband materials are removed from DOC facilities is absolutely crucial to the safety of both incarcerated people and DOC staff, the imperative cannot be used to justify subjecting incarcerated people to conditions that are even worse than those found in standard solitary confinement. Hearing reports of New Yorkers being forced to live in the stench of their own excrement absolutely horrifies me. Bypassing minimum standards of health and safety through emergency declarations or variance requests that do not protect the rights of those in custody is unacceptable. I urge the BOC to develop and the DOC to adopt best practices that remove contraband without subjecting incarcerated people to any form of punitive segregation. I'll end by stating clearly that we can and we must and solitary confinement in the city. And I urge the board to move forward with the rulemaking process. I also urge the Board of Corrections to research and adopt best practices for implementing alternative solutions to behavioral issues. San Francisco's Response to Stop Violence project is a successful, cost-effective alternative to solitary confinement and is one of the multiple models that should be evaluated moving forward. Thank you to the board for the opportunity to testify this morning. I greatly appreciate your time and consideration.
Thank you very much, Deputy Advocate. Ms. V. Good morning.
Good morning. Commissioner Brannon stated 80% less people are now in punitive segregation. Let me be clear, as I always am standing before you, that that is not because the DOC's doing, that's because of us advocates pushing it through. Just like last week's vote to close Rikers was not because the DOC's doing, it was because of us advocates doing. And I just also would like to thank, because she said severely mentally ill people and adolescents are removed from punitive segregation. I would like to say that's not because the DOC's doing, but because of us advocates. And I would like to state on the record to thank Councilmember Drum for pushing through in 2014 to remove solitary confinement for 16 and 21-year-olds. It had nothing to do with DOC. Very quickly, I spoke on separation status at the last meeting. And I am still wondering what is the protocol for people like me with invisible disabilities when it comes to the medical concerns going through those units. DOC has still yet to tell me what is the medical protocol to let people know of their rights around seeking medical help without going through those units. One thing I did notice while doing Brad H monitoring on the island, sometimes I'll take the bus across. I'll park in a regular parking lot and take the bus across. And all DOC staff and all civilian staff is allowed to get off the bus first, and they do not have to go through the Perry building the way all other individuals who take that bus go into the Perry building and are subjected to searches by DOC dogs. What's so important about that is that when we talk about the safety of officers, when we talk about people being put into these new solitary confinement unit called separation status, there's no concern about how other items are getting on the island. It's always brought to your attention from DOC that is always through the visitors or through incarcerated individuals. Yet I've directly reported here and at City Hall of witnessing officers bringing honey jack alcohol, Hennessy through iced tea bottles. And so my question is, what's stopping them from bringing in anything else? So when we talk about these units, we have to talk about all people coming on the island and it being safe for all individuals and holding DOC and their staff accountable. When we talk about people not having access to certain things within this unit, I've also testified and witnessed seeing females in standard solitary units not being allowed access to pads. So I ask you, after the mayor has tweeted over the weekend of all youth now having access to sanitary napkins for free, how does this apply in DOC facilities? Or are we still going to allow individuals to bleed directly on the floor? And excuse me for being so direct, but this is a direct need that needs to be directly addressed. And one last thing, Commissioner brought up the program desk, and what she didn't mention is that they're actually called shackles, and shackles are barbaric in this day and age. And it's time for BOC to stop allowing DOC to hide behind their abuses on barbaric torture with the statement of simply saying safety. I did nursing for over 10 years in psych units and ICU units, and every 2 hours we had to release anyone in restraints. And so what is making DOC's population so much worthy that they don't even have to apply by medical standards outside of the walls? Do your jobs, hold yourselves accountable, because I will start organizing around your own communities. Stay blessed.
Thank you. Julia Davis. Good morning.
Good morning. I'm Julia Davis with the Children's Defense Fund. It sounds like we'll be dividing our comments. So I'll focus on the variance now. We'll come back, I understand, to a public comment on the rulemaking. Is that true? Thank you.
We're actually going to run through both of our lists. We have two lists. We're going to run through both of them now.
Thank you. The purpose of this variance on the separation status, it is not to have the board endorse this application without addressing the specific rules and protections that you have created for people in the city's jails. It is for the purpose of you considering and understanding how to mitigate the harms and ensure the protections of people in these units. And you know, because you have read the variance request before you, that the issues that were discussed at the last meeting have not been addressed in the current proposal. These issues include the protections for young adults that this body created several years ago and have been held up today in the earlier discussion. This also includes the need for a presumptive release time, which was also discussed at the last meeting, which is also not included in the variance before you today. It makes no sense whatsoever for the department to return to you with such an inadequate variance request that does not address the issues you heard from the community and that many of you raised at the last meeting. It's simply unacceptable. You cannot move forward with approving this variance request today. Since I have some time, I'm going to go forward with the rulemaking on the restrictive housing. The fact that we are here today without a rule before this body and before the community to address the comprehensive issues that this board has engaged with for over 3 years is outrageous. What we did not hear today is the date and the deadline by which you will release the rules. We heard you'll return to us on the 31st to begin that rulemaking process, but we have no idea when we'll actually see that document, nor will we know how it reflects your initial proposal that went to the law department. We need to see all those materials before the 31st. Ideally, we need to see them today. If you're able to present to us the highlights, the summary, you are able to provide to us the specific rules that are being considered. Too much work has been done by you and by others in this room to continue to delay this process and to squeeze the community's ability to review and comment. I'm urging you to release these rules today. Thank you.
Thank you. Francis Gatellis. Good morning.
Good morning. I'm with Physicians for Human Rights and also with the Campaign for Alternatives to Isolated Confinement, and I've testified here before about the terrible psychological damage that goes with the use of restrictive housing and solitary confinement. But I don't want to address that today. I want to address the variance that you're being asked to approve. And specifically, when I read that variance, it made absolutely no sense to me. They want to put people in restrictive housing until they get the contraband, which they've seen on the screen. How long, if you see that somebody has contraband, how long does it take to take it away from them? Probably not more than a few minutes, and in most cases, maybe an hour. The one exception to that would be if I swallowed something. I could swallow drugs, maybe I've even heard people sometimes swallow sharpened razors. But then they go on to say in that document, because the person has this contraband, now we can't let them take a shower because on the way to the shower they could distribute the contraband or they could injure somebody. Well, if I've swallowed the drugs, and they're in my stomach, how the hell can I sell them to other people or give them out to other people? And if I've got a razor blade in my stomach, how the hell can I hurt somebody else while it's not in my hand? So though the rule request doesn't even make sense, and I'm asking you not to approve it.
Thank you. Kelly Grace Price. Good morning.
Hi, good morning. I'm Kelly Grace Price from Close Rosie's. It's nice to see you all. I've been standing here since 2014 talking to this board, and of this board, I only recognize 4 people that were here in 2014. Every time there's a major vote, people that have been the most robust oversight advocates that are members of this body suddenly disappear. This has happened again and again, and members of this board are replaced by people who don't have the institutional knowledge that is needed in these positions. I saw it happen in January of 2015 when you, Ms. Austin, were appointed and we had the vote on ESH. I saw it happen when you, Ms. Sherman, were appointed. That day we had a vote on ACS. This has been a pattern of the administration, and it needs to be pointed out that the board is being stocked like a fish pond. Sorry, it's a very inappropriate metaphor. I apologize. That was not scripted. But it's outrageous that this keeps happening. And of course, I was late this morning, and I wasn't here for the beginning, but I'm assuming there was no day dedicated to Brianne Himmel like there was to the former director of this body upon her departure. And I chagrin, and I sincerely thank you. I sincerely regret that Honorable Judge Hamill, of course, was dismembered from this body and that she was not acknowledged. I'm very angry about that. I also want to talk about the ESH vote because it has a lot to do with the restrictive housing and the separation housing votes that are about to happen or that are being considered. If you remember, when we created ESH, part of the conditions were that certain reports had to be provided monthly to the board. Commingled housing reports were mandated, I believe, as part of the ESH approval process back in 2014. And commingling, meaning units that include both youth and adults, those reports are still given to the board monthly. But there was another report published in July on the Board of Corrections website that had conflicting data. And I think the board is probably aware that there seems to be no small amount of enormous monkey business going on with the reporting from the department to the board about which units were actually commingled, true commingled units, and which were just kind of lightly considered commingled. You know me, I really drill down into the data that's provided. I'm proud of my advocacy as a survivor of Rikers that I'm able to actually understand and read through the BS that's produced very often in the reports that appear on your website. And I'm outraged that for the last 4 years, we've literally had false information provided to us about who is in those commingled units. It's a crime to produce illegal or doctored data. It's a misdemeanor. I could tell you the statute, the specific statute, if you care. I'll also, of course, include it in my testimony. But this keeps happening. And if the conditions for all of these variances and rulemaking changes are not being adhered to, the board needs to step back, reevaluate its oversight processes before it moves forward with any of these votes. Like I said, it's a misdemeanor. I believe that this statute is New York State 195.00, official misconduct, which is a misdemeanor. We know how many people are thrown on Rikers for misdemeanors, let alone, and I just don't want the irony of the situation to be lost on you. Thank you for letting me speak. Of course, I will submit my analysis of this rotten data to you in writing, but I sincerely hope that you will look very long and hard at what is being produced. And I might just add, and thank you for the extra time, I've noticed a lot of people are disappearing from the BOC staff. the best people. This is alarming. This is egregious. We need the most robust minds with institutional knowledge on the board right now while we're changing the scope of our borough jail rebuild plan. And I'd really like you to take this seriously. When you see people disappear, ask questions. Don't just ask the people at the top level of the BOC administrative staff. Get to know the people at the bottom end of it, because they're the people that their voices are being buried, but they're the ones collecting the data that we need to make these decisions off of. Thank you for letting me have a few extra seconds.
Thank
For
you.
these proceedings.
Vidal Guzman.
How you doing? My name is Vidal Guzman. First, I want to say thank you for having me here. First thing I want to say, I'm an organizer from Just Leadership USA that I've been leading the Close Rikers Island campaign. We should ask ourselves, where is a point of our life where we stand? As a person who had this 2.5 years in solitary confinement, what we will pass or would think about passing today is still solitary. How many times and how many people do we have to lose? How many people do people have to be taken out in body bags to understand that solitary confinement is killing people? I am a survivor of solitary confinement. For people who have never been in solitary confinement, imagine you being in solitary confinement for 23 hours and the only time you step out for an hour is to another cage. What does the mind does to a person who is 19 years old, knowing that the mind doesn't fully develop to 25? What does it do to people who are in solitary confinement for so much? 30, 15 days, even 8 hours? Anyone here, even the Department of Correction, even advocates, would not survive, mostly survive solitary confinement. We have a time in our history and a time for us to step up, to do something right, to do something bold, to push the city to think different. Solitary confinement been killing people. Killing people. When we make rules, laws, policies, let's remember, these are impacting human beings. Human beings. When this is all over, what will we do? And when we leave these seats and we do whatever we have to do or further in life, how will we leave our presence? You have heard people who have survived solitary confinement. You have heard people who are telling you facts of what it does to the mind and being in solitary confinement. You have heard many different stories, facts. How many times as a whole will we have to be bold enough? What are we so scared about? What is so scary about ending solitary confinement? What is it so scary about as a city stepping into a light of a different shape of criminal justice system? What we do today will matter tomorrow. Not what happened yesterday. It's what we do today will matter tomorrow. The only thing I have to say, I'm not only speaking for myself, because my whole hood been in solitary confinement. So when I speak with people from my neighborhood. So take a bold move and do what's right. Thank you.
Thank you. So as I stated earlier, I am going to run through both lists that I have for public comment, so the variance list and the rulemaking list. So Kayla Simpson.
Thank you. My name is Kayla Simpson. I'm a staff attorney at the Prisoners' Rights Project at the Legal Aid Society, and I'd like to build on the comments by our director, Mary Lynn, by Ms. Parrish, and other advocates, because critical moments like today deserve all of our voices. deserve repeating. And the mayor secured a vote from City Council last week to build 4 new borough jails, and he secured it with promises in every press conference, every public statement, every City Council hearing, every forum imaginable, that this marked a new day in corrections, a new day in the way that the city treats people in its custody. And when the community expressed fear about how real those promises were, the mayor and his administration, from City Hall down to all of the agencies like DOC and every other actor in the city, asked us to trust them. This was a unique moment, they said, to reimagine incarceration in this city. Please trust us. So what would reimagining city jails look like this week, which is days after that vote, that is being touted as historic? Would this first opportunity here at the Board of Correction hearing demonstrate culture change? Would it be evident here in this forum? No. One thing that's clear today is that all of the fears that the community have, all of these concerns that the city would truly commit to reform, they're still alive. We appreciate the summary of the current draft. We appreciate it truly. But the board must publish immediately, this moment, the proposed rules right now so that the public can see them. And for the reasons Ms. Parrish mentioned, I won't repeat her. But reform and culture change, these things are not in press conferences. They're not in public statements. They're in details. Details become practices that become things like separation status that affect human beings, that cause suffering to New Yorkers, to citizens of this city. And we can see this in the way that DOC treats isolated confinement, restrictive housing, whatever they call it this week. We see the way, for years, the way that a housing unit may not be called punitive segregation, but it's punitive, and we all know it. We know that separation status is punitive. It's clear. We see it in the way that we're still allowing in the summary 60 days for some offenses when we know that the international standard is that more than 15 days is torture. That's a detail that's important. And we see it in how the department calls it program desks. They're restraint desks. They're shackles. They are the iconography of some of the darkest parts of this country's history. Details matter. Reform happens not out there, but in gritty places like rulemaking here. It happens here. And we need to see right now the details proposed. And I think it's incumbent on us to ask why the city is not publishing those things. It makes it look like there's something to hide. And we need to know what that is. This board is empowered by the city charter to be independent, to be the watchdog of what happens in city jails. And we implore you to take up that mantle. All eyes will not only be on you on October 31st, they're on you today, they're on you every day until then. Please act. Thank you.
Thank you. Donna Hilton. Good morning.
Good morning, everyone. Thank you for having us here. I usually come with a scripted story to tell, but I want to be just very clear and direct this morning because I feel it is very important. On October 6th, October 7th, Alexandria Ocasio-Cortez tweeted out a piece of a story about a woman who, as an adolescent in 1985, was arrested and detained on Rikers Island for 18 months. As soon as she was brought into Rikers Island and gone through the receiving room and through the processes of being numbered, fingerprinted, photographed, she was told that she was going to be placed into a unit called administrative building, administrative segregation. She had no clue what they were talking about because she's never been arrested before, never been involved with the criminal justice system in any way, and she was an adolescent at the time. They took her to this administration building and put her in a cell. And 24 hours later, someone came around to ask her or to check on her. She told that person that she was having nightmares, that she was having problems, and she needed to see someone. She needed help. 24 hours later, she was still asking for help. She was then taken to the medical unit to be seen by someone. She had no clue who. So she told the person when she got to the medical unit what was going on, that she was having nightmares, she was alone, she was afraid. She's never spoken to her parents. She didn't know how her child was. Nothing had happened through the process of her detention. And she was told that she would be helped, that she would be given something to help ease her, to work with her nightmares and her fears. A few hours later, an officer and a nurse came to this administrative segregation unit and gave her psychotropic medication that she had never taken in her life, and she was told that she had to take it. She had to take it. And so, following the rules and being good and listening, because she's never been through that process, she started taking these psychotropic medications. And she was doing this for months, actually 6 months. But during this 6-month period, she was not allowed any kind of contact with anyone. She was not allowed to make phone calls. She was not allowed to interact or to find out why she had to take this medication. So I'm going to wrap this up to say that this young woman who had nothing in her cell and no one came around to check on her periodically, as they say they do, was forced to flush the toilet in that cell about 5, 6, 7 times to make sure the water was clear, just so she could put water on her lips because she was dried out. She was suffering. She had nothing to drink, she had nothing to eat, and nobody was responding to her. She later learned that that same administrative segregation cell or building was the same thing as solitary confinement, was the same thing as protective custody, was the same thing as the segregated housing unit, was the same thing as just being isolated for everyone. And she had no clue what she was doing, and nobody would help her. She had to go to court to get out of that. She had to fight in court to get out of that unit and to make sure that she was taken off the medication that docs told her she had to take, or she would be in trouble. But as she went to court one day to get off that medication and to fight her conditions, a shank or blade or razor was supposedly found in her cell. And then she was told that when she returned to the island, that she was now placed into solitary confinement, the segregated housing unit. She stayed in the same damn cell she was put into when she first got there. So I say to you that all the words, all the framing and the naming of these buildings and all these conditions are the same exact thing. Solitary confinement is the same as protective custody, is the same as administrative segregation, is the same as every piece of everything that was labeled here this morning. And it hurts me that 35 years later, that 20-year-old child who is now 55 years old has to stand here and say, shame on you for lying and saying that these conditions are something that they are not. Shut it down.
Thank you, Ms. Houghton. Kelsey Davila. Good morning.
Morning. I'm Kelsey D'Avila with Brooklyn Defender Services. I just want to thank the board for their summary. We do appreciate it. But I will say that we are disappointed that the voting to initiate public rulemaking on restrictive housing is not happening today. It was reported in the city that Mayor de Blasio, and I quote, said, "Not there yet," on reducing the use of solitary and isolation. We find his comments offensive, not just to the survivors of solitary, some who are in this room with us today, but the ones who are currently in isolation and the ones who have died because of it. Earlier this month, our office met with 2 people who were on deadlock status, and both were held in their cells for 24 hours a day. They did not have access to a shower, telephone, or services. Their first time leaving their cell was when our office went to visit. In one of the cases, our client was told he was moved there for his safety due to receiving some threats. And instead of the department providing other forms of housing, moving him to another facility, instead they resorted to punishing our client for seeking help. He was denied due process and further isolated until our office intervened. On another case, earlier this month, our client was in ESH level 2 and then moved to the restraint unit at NYC. He didn't know why he was moved, how long he was going to be there, or even what the unit was called. He was under the impression that it was another ESH. And he was rightfully frustrated. Staff who knew him, who interacted with him day after day, when there did not know why he was there, did not know how long he was going to be there. No communication was given to him. He was upset, and now the staff is upset, and it's an endless cycle that just fuels itself. It creates an unsafe environment, not just for the people who are incarcerated, but for the staff as well. People are confused, frustrated, and understandably angry, and instead of DOC simply communicating why people are there and what's going to happen next, they let people suffer and for tensions to rise. That's why a comprehensive rule package on restrictive housing is essential for the safety of all people in our jails, because decisions are made, people are moved, communication is lacked, and transparency is rare. And this is something that rulemaking can address, and it's shameful for the mayor to block it from happening. And again, we thank Michelle for providing the summary of today, but the board must publicly share the proposed rules immediately and be open to public discourse. Because if the mayor was sincere and committed to culture change that he so proudly states in his press conferences and into the media, then he would start with these policies and end DOC's abuse of power today. Thank you.
Thank you. Liz Myers. Good morning.
Good morning. As you can see, my name is Liz Mayers, and as you can see, I'm with the Jails Action Coalition. What I'd like to say today is that this board is not known for its independence and transparency, but here's your chance. Your chance is that you can publish the rules immediately, not something that usually happens around here when we know at the last minute, although things have improved. You can publish the rules immediately so that we can study, all of these activists can study, and we will know what happened before and what happens afterwards. I would also like to honor Judge Hamill, who has, through her diligence and her passion, worked so collaboratively to support the thousands and thousands of people, past and present, who have been in the Bing, the box, all the versions of solitary confinement that have come before this body. And I hope now we will get a chance to change it and for us to work collaboratively with you around these new rules. Thank you.
Thank you. Scott Paltrowitz. Good morning.
Good morning. Thank you all for your ongoing work and for sharing the summary, but I have to echo what everybody else said here. This is really atrocious. It's an abomination. Are you a real independent body, or are you a puppet of a mayor that is trying to keep the torture of solitary confinement in our jails? He may not be ready, but the world is ready. City policymakers besides him, you've heard some of them today, are ready. People all across this state are ready. People all across this country are ready. Every leading presidential candidate has called for a complete end to solitary confinement. Finally, policymakers in this city, in this state, around this country are making the demand that people who have lived solitary confinement, who've had family members, who've lost family members, and their allies have been making for years, including before this board, that this practice is torture, it's barbaric, and it has to end. You all have the power to end it. And when I say end it, actually end it. You heard what Donna said. We can't just create other forms of solitary. This has to be meaningful change. This has to really end. Yesterday, the experts on this topic, people who've survived solitary, family members and their allies, released a blueprint for how to actually end solitary confinement. And what that means is no one, not one person, no matter what they call it, should be in the kind of isolation that we know is solitary confinement. And the board's minimum standards for 14 hours out of cell per day need to apply to every single person. There can be no exception to that. And it can't just be out of cell, alone in a cage, maybe with one other person, or alone entirely, and call that something other than solitary. It's solitary confinement. And so people have to have access to meaningful human engagement, congregate programming. People, the bottom line is we need to treat people as people. Every single person in these jails is a human being that is worthy of dignity, respect, and support, not isolation and torture. So please, use your power. Use your power. You have it. You can do it. And if you don't do it, then the people in this room and the council members and the public advocate who's spoken, we will end solitary, as people have said. Solitary will not be in New York City. Solitary will not be in New York State. Solitary will not be in this country. And please, take your step now. You have the power, whether it's by October 31st or whenever you're going to do it, as soon as possible. End this torture fully and completely. And let's use the ending of solitary confinement as a springboard to end the entire racist, punitive, horrific incarceration system that we have in this city, this state, and this country. Thank you.
Thank you. Councilmember Perkins. Is the council member here? Oh. Okay. Anthony Posada. We're in the comments, the folks who signed up for comments on rulemaking. Okay. Ms. V?
My name is Minister Dr. Victoria A. Phillips. Everyone knows me as Ms. V. I joined the Jails Action Coalition in 2012 while still working on Rikers Island because of the barbaric treatment that I directly witnessed. And I know so often formerly incarcerated individuals are not believed when they come before this board or City Hall to speak their truth. For the past 8 years, I have given board this exact truth. And everything that I've spoken on the record, if you fact check, has turned out to be the truth. I thank Judge Hamill because of her bravery and demand that the Board of Corrections follow her legacy and do what is right to save a life. You all have levels of expertise in many areas. You seem to be an amazing board on paper, yet your political alliances bind your conscience. You have an MD on board, yet I see countless meetings where several medical concerns are addressed and the MD remains mute on the record. You all need to be brave. I've been threatened by actual correction officers because of my organizing, yet I have not stopped. In 2015, I had emergency brain surgery, yet exactly 1 week later, I had my neuro ICU calling into the advisory board that I've been a member of for the last 5 years for the Department of Correction because I wanted them to know that I too would not stop. I show up and I do the work. Every single detail that I put on this record has been proven fact. And as you decide these rules, I want to make it clear that you need people like me to be a part of that conversation. You need people that's not having no contract, that doesn't have to worry about how they're going to pay their rent, coming from DOC to speak the truth. Because truth is power, and you have the power to make the direct changes that need to occur immediately. So utilize your power. Stand up. You have an actual distinguished officer on your board. Stand up and speak the truth that you know that I tell quite often on this record. Be a man. Be a member of society. Remember the people that you are supposed to speak for, not just the people in blue. Because many times bullies with badges walk around into this room. Be a person of society. Have some dignity. Remember that we all have to make changes. We all have to unite to do what is right for humanity. As an Army brat, my mother taught me you leave no man behind, dead or alive. And as she's buried in the military cemetery, I fight with all my right to do what is right. I fight with all my power to do what is right. And you need to publish that draft. That's what democracy looks like. Democracy is not a dictatorship. Democracy is showing us what you're working with and what you plan on changing. That is true democracy. That is what my parents served for. Do what the hell is right.
Thank you. Councilmember Perkins. Good morning.
Good morning. Good morning. So, thank you so much for being here and having what I consider to be a very, very serious challenge for us as a city, as a people, as a challenge to our humanity and our decency. And I'm optimistic that this effort will lead towards something much more progressive and oriented towards what our nation is supposed to be standing for. Thank you so much for being here. I would like to acknowledge the New York Campaign for Alternative to Isolated Confinement and Jails, Action Coalition, New York City for organizing this press conference, this event, and their tireless leadership advocating for those, quote, behind the wall, being abused by city and state-sanctioned torture, what some would call the being in the box, quote unquote, and others call being in solitary confinement. New York City continues to have a human rights crisis right in our own backyard. Our correctional system is broken. It spends more time abusing and corralling humans like animals than it does helping them to heal, learn, and grow. This inhumanity is predominantly visited upon people of color who are so often treated unfairly and with a prejudiced approach. This unconstitutional inequity spans our entire criminal justice system. Solitary confinement is particularly egregious and very inhumane. The repeated incidents of torture and subhuman conditions at Rikers Island and other city jails are cause for immediate action. I proudly stand in solidarity with all of you to ending solitary confinement in New York City. If we are to advance as a society of human beings, as well as a government that creates effective policy, we must move from a distrustful, disciplined and punished model so no one hurts others and respects core issues of all of our people. The pursuit of ending solitary confinement does not end here, locally here in the city. There is legislation currently in Albany called the Halt Solitary Confinement Act. While in New York State Senate, I was the lead Senate sponsor of that bill, which challenges the status quo policy of the use of solitary confinement, wisely substituting a rehabilitative and therapeutic model in place of isolation so that individuals can receive the programming, support, and intervention needed to help them rehabilitate and grow. How long will we allow this state-sanctioned torture to continue while the most defenseless and vulnerable amongst us are subject to inhumane treatment? We are optimistic that the next legislative session leadership in Albany will take on the mantle of ending solitary confinement and passing legislation appropriate to ending it. Please know, while I am here in this council, I'll continue my aggressive advocacy on this matter and can be looked upon as a close ally. Thank you.
Thank you, Council Member. Carmen Pinheiro.
Good morning. My name is Carmen
Good
Pinheiro.
morning.
I'm the Director of Organizing and Community Engagement for the Bronx Defenders. But I come to speak today. We also have Julia Solomons was going to speak today, who's one of our wonderful people who work with us and is part of the Jails Action Coalition. But I'm coming to you just to speak particularly about my own experience. So I come from a neighborhood in the Bronx on 174th Street and Clay Avenue. And in my neighborhood, we've had many raids, many people getting arrested, sometimes just by association, and sometimes for some of the most minimal things that you can imagine, right? And what ends up happening to people in communities like mine is that when they get incarcerated, everything changes, right? Incarceration doesn't just affect one individual, the individual that walked into that system. It actually affects entire communities, entire families. And one of the things that we've learned in all of the studies that we have heard, we hear about it, we know about it, when children are separated from their families, when you have children that don't have care or concern or even any type of human contact, you have a different set of children. You have children that are already starting out with specific mental health issues because they don't know what it is to have interaction. So when we're sitting back and we're looking and we're talking about solitary confinement, we could use all the beautiful words that we can imagine. But recognize one thing. Recognize your own employees and staff in the Department of Corrections that are working with individuals. Recognize that those people are not social workers, are not trained, do not have the ability to fully understand what is it that someone is going through when they're dealing with a mental health situation. 85% of people who are incarcerated on Rikers Island and the boat are not even meant to be there. They have not recognized what are the true backstories and issues of the communities that they're coming from that don't have the opportunities that many other communities have, that are already being targeted and over-policed and are coming into situations of incarceration without any type of services, resources, or help. There can be thousands of resources, but there are not enough access to resources that come into our communities. And I have personally witnessed and seen how anyone who has gone through incarceration and has had to deal with solitary confinement, what are the changes that you see? Imagine being in a room with no windows, a little toilet, no place to really spend any time in, no one to talk to. I mean, there's a movie, right, where you're talking to a basketball. Who remembers that movie, right? He didn't have anybody, right? Stranded on an island. That's solitary confinement. What does it do to the psyche? What does it do to the family? People come home and they start, their eyes are wandering in the air. They start to create their own solitary confinement inside of their brains, even when they are surrounded by other people, because that's what they've recognized and witnessed and lived through. They don't say, we had this experience. I have survived solitary confinement. This is what you're hearing from people who have had these particular experiences. You have a duty to recognize that you are a human being. When we talk about language justice, in the jail system itself, people are considered bodies. And that's so that your own staff can recognize that their own, at times, egregious behaviors, they have to go home and live with it. They have to sleep at night. Could you imagine sleeping at night and knowing that there's somebody locked in a jail cell that might be killing themselves slowly, mentally, because now they're locked in a box for life? You have the ability to change the system. We can close down Rikers and we can close down the boat, but until we change the nature of the actual incarceral system, of the people who are running that system, and until they recognize they're working with individuals and people and must have better and humane conditions so that when people go back home, they have the real opportunities, the real resources, and the real needs to be met, this is not an equitable system. Where I live at and in my community in the Bronx, we do not have what many other communities have. And we already are fighting to come out of the dirt. So I'm asking you, do something different. Change that system, because you do have the opportunity to do that. And if you don't do that, you are failing us. And we need you to do better. Have a wonderful day, and thank you for listening.
Thank you. Councilmember Levin. Good morning, council member.
Good morning. How are you? Good morning, members of the Board of Correction. My name is Stephen Levin. I'm council member. I represent the 33rd District in Brooklyn, and I'm here today to speak in support of ending the practice of solitary confinement and punitive segregation in New York City's jails. The call to end solitary confinement has reached a breaking point. Criminal justice advocates, correctional experts, healthcare leaders, public agencies, and elected officials at all levels of government have recognized the need for change. We are past the point of debating the harmful effects that punitive segregation has on a person. Recognized as torture by the United Nations, study after study has shown that people kept in severe isolation are significantly more likely to have psychological impacts, inflict self-harm, and be more at risk of reincarceration and death, either by suicide, homicide, or overdose. Solitary confinement doesn't solve the issue of potential violence that led a person to being isolated in the first place, but there are alternative models that do improve safety. Units that separate detainees from the general population but don't put restrictions on out-of-cell time and are more effective at reducing violence and promoting safety. I understand that I didn't get a chance to see it, but I know that the CAPS units at Rikers Island have been effective. There is no more justification for the continued use of punitive segregation housing. I want to be clear that the ending of the use of solitary confinement in New York City jails requires that we address all levels of severe isolation used as punishment, including enhanced supervised housing units and punitive segregation units. Multiple restrictive housing units use punitive isolation practices that limit out-of-cell time for individuals deemed high risk, quote unquote, with no clear oversight of why individuals are placed in those units or how they can appeal the decision. It is important that we create clear standards across the board to ensure accountability. And so I'm here today in support of establishing minimum standards for all people in incarceration to be treated fairly, including getting rid of restraint desks and enabling the Board of Corrections to have better accountability in the system. This is a critical step. I'm also proud to stand with the Jails Action Coalition and the Council's Progressive Caucus in urging the rulemaking to apply minimum standards of 14 hours of out-of-cell time to all people in city jails and remove exceptions for those standards for punitive segregation, enhanced supervision housing, and other forms of restricted housing. I want to thank the board for their rulemaking consideration around restricting solitary confinement and other forms of isolative punishment. And I hope that you will continue to take steps to end this inhumane practice. The Board of Correction is needed to provide an important independent voice over our city's correctional system, and I urge you to make the proposed rule public for everybody to comment on immediately. And just one one note just around restraint desks. I went to Rikers a few times over the last several weeks and was at Rosie's in the restrictive housing unit. And I was shocked when I went that I was talking to two women who were both handcuffed to a restraint desk in their out-of-cell time. So however many hours they had on that day, a few hours, not many, they were chained to a desk. And they weren't, there was only a few people in this unit, so there's no real risk of violence or, I think that there were more correctional officers in the unit than there were detainees. And they were there. They were given crayons and a coloring book and were chained to a desk for their time out of their cell. And that was shocking, and that shouldn't happen. So I urge you to commence the rulemaking process immediately, and I look forward to continuing to work with you. Thank you.
Thank you, Council Member. The final speaker is Nicole Triplett. Nicole? Good morning.
Good morning. Hi, again, Nicole Triplett, Policy Counsel at the New York Civil Liberties Union, also known as the ACLU of New York. The New York Civil Liberties Union respectfully submits this testimony to urge the Board of Correction to oppose the recent variance requests that would permit the department to place people in separation status housing and effectively expand its use of isolation. It also urges the board to move forward with the rulemaking process in issuing new rules for restrictive housing. Since July 19 of this year, 35 individuals have been placed in a solitary holding cell that has been designated as separation status housing. Despite the label, the designation is a form of solitary confinement or isolation that operates as an exemption from the minimum standards placed on the use of isolation. However, it merits the same restrictions given other forms of isolation to at minimum prevent misuse. Given the lack of regulations on this form of isolation, it is unclear that whether the department is using the designation to simply curb or bypass the regulations that would ordinarily apply to solitary confinement, including the rules that are supposed to prohibit the isolation of individuals with serious mental and medical conditions and individuals under the age of 22. Those already designated separation status include people who the board and us advocates have fought for years to protect from solitary confinement. It's also unclear what procedures the department is undertaking aside from conducting the ionized body scan to detect contraband. It's also unclear for how long people will be in isolation, and given the results of where there's a lack of due process protections, we've also seen how racial bias unchecked will continue to contribute to the already existing racial disparities. So to permit this rule change would ignore the recent tragic death of 27-year-old trans woman Laylene Polanco, who died while placed in punitive segregation despite having a seizure disorder. Her death, as well as countless others, underscore the dangers of isolation, especially isolation without proper compliance with the limited restrictions that already exist. Notably, these proposed rule changes like this one will continue to detract from the more meaningful efforts to change the culture of Rikers and protect people from the abusive use of isolation. Instead, the department should be held more accountable for limiting its use and ending all forms of prolonged isolation and other abusive solitary practices. We've already seen the problems with the variance requests made for the placement of 19 to 21-year-olds in enhanced supervision housing. Since the ESH ban for young adults was passed, the department has continuously requested and received variances from the board, who has waived its compliance with the requirement at least 5 times. The city cannot afford to grant the department another way to take steps to avoid compliance with the already limited restrictions that exist today. Less than a week ago, the City Council voted to close Rikers and proceed with plans to build 4 small borough-based jails. Deciding to close Rikers served as a signal and acknowledgement of the untenable culture and inhumane culture of Rikers. Central to the board's focus moving forward, we urge the board to make every effort to append to the culture of violence by doing the following as I close. 1, issue rules that will protect people who are 55 and older, 21 and younger, pregnant and in postpartum recovery, and those who have certain mental, physical, and medical conditions from all forms of isolation. Issue rules that will end the use of isolation that extends beyond 15 days, and also ensure access to programming that is trauma-informed and truly rehabilitative. As I close, the board must not continue to sanction torture of incarcerated individuals, and the New York Civil Liberties Union urges the board to reject this variance request for separation status housing and move forward with the rulemaking process.
Thank you. That concludes our public comment on the variance and the rulemaking. Dr. Cohn?
Hear me? Yes. I'd like to just take this opportunity. We're not going to have any more discussion, I believe, on the board today about the restraint rule. Is that correct, Chair? About the restraint rule.
Rulemaking?
Yes. So I want to take this opportunity first to say how proud I am of New York City over the past week. It was quite extraordinary. It brought tears to my eyes. We're not done, but it was an extraordinary accomplishment that was achieved by everybody in this room, and we should be, and I am very, very proud of that. And in that context, I wanted to speak as a member of the board, and I hope on behalf of the board, about Brianne, who served on this board for 6 years, who served on every rulemaking process that we've had, I think, perhaps, except for maybe even the injury reporting issue, who worked tirelessly and effectively and made a tremendous difference to the people locked up in our jails. And it is disturbing, upsetting, and a clear indication of the active interference by City Hall, although it was denied by the mayor and his spokespeople in today's city paper, that not allowing her to participate in this vote was meant to change the dynamics of this rule. And that's why without having anyone to replace her, she was denied the right to vote with us today. And that's also why the vote has been, we're not having a vote today. I mean, we submitted a rule which I'm going to ask the board to post on its website over a month ago. It is not true that the city says that they have not had time to review this. It is not. They have had plenty of time. It is not true that representatives of City Hall have not interfered in the process of board discussion of this rule, and it is not true that City Hall has not blocked the certification process. I am on the rulemaking committee. I am not aware, and this is based upon us having independent counsel review the subject. I am not aware of any legal matters that are at issue, which is what the law department's brief is. They're supposed to not certify a rule if there are legal issues which require clarification. I have not been provided by the law department or by the acting chair of any legal issues which are significant. Those which we've had a chance to review with counsel were deemed, in a more in a friendlier way, non-meritorious than what I've been describing so far. So you know, we're going to meet again on October 31st. The only reason why we're not voting today is because the city wants to delay our vote in order to remove additional items from the rule. Now, the rule as it stands right now, and I don't even know what that means because there's really no rule there, is terrific. It's not perfect. It's going to be great, and you know, but it was better, and it will be worse if we delay publication. And it will certainly be more. It will be worse if you don't have a chance, and the citizens of New York do not have a chance to understand what we submitted to the law department over a month ago, and what comes out of our rule next week, because during the CAPA process, you will have the opportunity to identify issues that were placed by our rulemaking committee into the rule. We voted for this rule in representing the Board of Correction, and you should know what we thought was important and what has been removed under political pressure. Now, it is the time. You know, the mayor's statement is wrong, and I just want to honor. You know, through this process, we will honor Brianne, but I just want to thank her. I hope she's watching now for all the work she's done, and to thank all of you for all the work you've done, and ask the chair to post on our website the rule that we submitted to the law department a month ago. Thank you.
Thank you for those words, Bobby. Thank you. As I stated at the top of the meeting, we are planning to reconvene on October 31st. We intend to publish the draft rule in advance of that meeting. We're going to turn now to the separation status variance request, and Michelle is going to provide an overview.
I'm going to give an update of board staff's oversight efforts of the separation status unit and body scanning since we last reported on this at the September public meeting. A body scanner is a security tool that utilizes a low dose of ionizing radiation to conduct full body scans capable of detecting objects placed on, attached to, or secreted within a person's body. In October 2018, Governor Cuomo signed a law that allowed the department to use body scanners in the city's jails. The scanners can only be used on people in custody, not staff or visitors. The board joined the department, city council leaders, COBA, and community-based organizations to support passage of the law, citing the scanners as an additional necessary tool to prevent violence in the jails. In supporting the legislation, the board said that the scanners would only be effective if used alongside the department's other violence prevention initiatives, such as increased programming, PACE unit expansion, additional staff training, further reforms to restrictive housing, and a continued citywide commitment to reducing the jail population. In July 2019, the department began using body scanners on people in custody to identify contraband. If a person scans positive for contraband or refuses a scan, DOC places the person into separation status. Today, body scanners are in operation at 4 facilities. Everyone entering DOC custody must be scanned, and scans can also be used to detect contraband after certain other events. If DOC identifies contraband on a body scan, in other words, a positive scan, or a person refuses a body scan, DOC places the person into separation status. The department keeps people in such status until they receive a negative body scan or post bail and are released from custody. Separation status involves 24-hour lock-in, except for the offer of a daily shower. CHS conducts daily medical rounds on the unit. The department's variance request states that for people placed into separation status, it is unable to meet minimum standards on the following: haircuts and razors for shaving, closable storage and table or desk space, lockout time, recreation, access to courts and legal services, law library access, access to legal documents and supplies, visits, correspondence, incoming packages, publications, access to media, and religious practice. The department and CHS are mitigating some potential health risks of separation status placement by requiring a ratio of 1 correction officer to 1 person in custody and uninterrupted supervision of each person in this status. Board staff has closely monitored the separation status unit since it opened on July 18th. Here are our findings. There have been 34 placements into such status. This includes 6 placements since our last public meeting on September 10. Each placement has been documented on the board's website, including date of placement and date of release. The board reviewed placements between July 18 and August 28, 2019. Of the 19 placements, 6 or 32% resulted from individuals refusing to be scanned, while 13 or 68% were positive scans. Stays in separation status have been between 1 and 3 days, with 13 or 68% for only 1 day. 11 or 58% of the 19 placements were young adults ages 18 to 21. 9 or 47% had a Brad H designation, including 1 person who was placed twice. The unit does not have air conditioning. However, the department says it will use West facility as an alternative facility for separation status if a person is heat sensitive. 10 or 56% of the 18 people placed into separation status were Black, and the other 8 or 44% were Hispanic. A person who was placed in separation status did not receive his medications on 2 days while he was in the unit. Initial gaps in medical rounding have been resolved, and as of August 2019, the separation status unit logbook has documentation of daily CHS rounds. Earlier stays in separation status were missing logbook documentation of offers to scan. Since mid-August, however, the department has been consistently documenting such offers. 3 individuals have missed court dates due to placement into separation status. According to DOC, since it began using body scanners, 20 people have been placed in separation status because of a positive scan. Of those 20, DOC recovered contraband from 4 individuals, while the remaining 16 cleared the scanner with no contraband recovered. An additional 22 people immediately surrendered contraband after a positive scan and prior to placement in separation status. DOC officers and captains who use the body scanner receive training on use of the scanner and interpretation of images. Rules of the city's Department of Health and Mental Hygiene require DOC to post specific language at all machines in English, Spanish, and any other languages DOC deems appropriate or necessary. In 3 of the facilities, board staff found the signage was not clearly visible to people entering the scanner, and none of the areas had visible signs in Spanish. The board appreciates the hard work and creative thinking of the department and CHS on the initial planning and rollout of body scanners in separation status. We also recognize the continued focus on strengthening procedures over the past few months. This is a challenging and critical security issue, and we anticipate that body scanners in separation status, appropriately and sparingly used alongside other violence prevention initiatives, will contribute to decreased violence in the jails.
Thank you, Michelle. Would the department please present their variance request?
Did I say 6 months? No. Their request is 6 months.
Good morning.
Yes, hi. Good morning. My name is Chief Stukes, Bureau Chief of Security at New York City Department of Corrections. Pursuant to Section 1-15C of the New York City Board of Corrections Minimum Standards, the New York City Department of Correction requests a limited 6-month variance from various BOC minimum standards for the purpose of maintaining the safety and security of the department's facility when individuals in custody are known or reasonably believed to have dangerous contraband secreted on or within their body. The department is seeking a variance from provisions in sections 1-03 through 1-09, as well as from provisions in sections 1-11 through 1-14, and listed in the variance request. Letter sent it to the board on October 11, 2019. I would just like to start by saying, since the use by the body scanners within the department in mid-July, it was new to the agency, and we experienced some challenges with regards to signage. I would just like to state for the record that as pertains to those signage, those issues were abated. As noted, to date, the document that you would see before you on the PowerPoint presentations lists 34 individuals that has been placed in separation status as of that date of that document. We have had 35 placements. Of those placements, we have discovered to date 38 contraband weapons. When you look at this, what's on the slide before you, there's 22 individuals who surrendered contraband immediately following a body scan, which is a positive image. You have 9 individuals who surrendered contraband prior to scan. So that is 31 individuals who were subjected to the body scanner whom did not go into separation status, which represents nearly 48% of individuals who had an initial positive scan. So I think that is great to state that the body scanner machines are effective. That is the different effects of having this device that we had in previous years, but was discontinued. 31 individuals, as I stated, who submitted the contraband prior to being placed in separation status. They're not going to separation status. And that 48 contraband items, as of today's date, is 51. Just as of yesterday evening, we had an individual who was removed from separation status, who surrendered 2 razors and 1 scalpel, which was secreted inside his body cavity during the initial placement, which was observed by staff during an inmate a contact visit. Of the discovery, 33 weapon discoveries has been taken out of circulation. Right, that'll be 36 to date, which is 36 weapons that could cause serious injuries, disfigurement, or death to persons in custody, staff, or even members of the public who are entering our facilities. With the breakdown, we have had discovery of 1 sharpened plastic. We will add the scalpel from yesterday, which will give us 9 scalpels, 1 hobby blade, 10 razor blades, and 14 sharpened metals next. And on the next slide, we'll just show some of the images of positive body scans that has been either surrendered prior to a body scan or immediately after a positive body scan. Scalpels, drugs, Suboxone, razors next. Hobby blades, ceramic scalpels, which with our existing security devices prior to the utilization of body scanners would not be able to be detected with the previous security devices which we had in use at our facilities, which would be the body scanners, the transfriskers, and the limited means of what we could do as regards to searching legally when persons in custody whom we have great suspicion are concealing or have contraband on their person. So I would just like to close by stating that, yes, the body scanners is new to us as being reused. However, it is definitely an effective tool, as our goal is just for safety and security and contraband recovery. Individuals placed in separation status are always given the opportunity to surrender any unauthorized item of contraband prior to be placed in separation status. And even at that point, once they are placed in separation status, they are continued given the opportunity to surrender contraband so that they could, weapons, so that they could be removed from that status. Myself and other members of the executive team personally appealed and tore this unit, encouraged to these young men to surrender contraband or submit to a body scanner image so that they could be removed from the status. Thank you.
Thank you. Are there questions for the department before we move to vote?
And we wrote letters to the state legislature. We wrote letters to the governor, I think. We understood the need for safety and security. It's very good news here to see the data that you had there.
Thank you.
I think it's so new, we have to be really careful with regard to the separation stuff. But I am euphoric that there are scanners on Rikers Island.
What was that last point you made?
I am euphoric that there are scanners on Rikers Island. We all saw a video that Chief, you or the Chief of Department brought to us where 4 people in a cafeteria setting moved to get weapons that they had hidden on their bodies, right? And to be able to fight that kind of fact is a thing to celebrate.
Thank you.
Thank you. Member Perino?
Well, I always said, you know, if people aren't safe, nothing else matters. I think the scanners, you know, like was said, it's really important because seeing so many people get hurt with cuts to their face and their body, it's very disheartening, and it's our job to keep them safe. It's the most important thing. I spoke to a few people, you know, the separation status, you know, and I would like to discuss maybe you, Chief Stoops, and also Chief Jennings, you know, maybe this week. You know, is it possible we could fit it into procedures that we already have in place instead of creating this new one, like maybe pre-hearing detention to create that automatic separation? You know, I've said that. Maybe there's reasons for it not to happen, but I think having a procedure in place instead of creating something new that we would have to vote on every 6 months might be something that we should explore. Separation is paramount. You have to separate someone when you believe they have a weapon. You have to keep our department safe by all means. But just something to maybe explore with the separation, because that's what we need is a separation. We need to take this individual that is known to have a weapon immediately out of population so they cannot hurt another person. Having access to that weapon, you know, if someone said if it's in their body, they can't have access to it, but we all know they put it in different places in their body and they secrete it different ways that they can grab it within seconds. I've seen people spit out razors in their hands and we couldn't see when they opened their mouth. And we also, I see people reach into their pants and all of a sudden come out with weapons within split seconds and they go right back within seconds. So the games out there that have been played and where people have been getting hurt is with this scanner, it's going to slowly stop. And not only the people that you found, just having that option, there are individuals that are not going to walk around no longer with razors just to knowing that they could be searched in that way. And I think we'll never be able to know exactly how many people have you stopped walking around with razors. I understand, you know, the need to end punitive segregation, But before we end it totally, we need to find a place where we can keep people separate and keep everybody safe. Because just by stopping something, you have to have somewhere else to go. People are getting hurt right now as we speak. I see people are getting stabbed and slashed, a few times a month. And we need to, and I think the direction you're going in, that's gonna stop it. But we need to stop that at all costs. So that being said, speaking about separation status, I think we have procedures in place that maybe we can explore to utilize that is already known to work, that has mental health referrals, and it has due process stuff that's already built in that we've been using for a while. So that's something that I would like to bring out here, even though you have my support at this point, because we have to take these individuals out of circulation so they don't hurt anybody until we can prove that they do not have a weapon on them.
No. Thank you.
Thank you.
Yeah. This is
Mr. Richards.
just a comment, just reflecting on the past week and where we're at right now. And right now, we're really at a time where we have to get beyond punishment, and we have to get beyond the extremes of isolation and the extremes of how we do our business when it comes to incarceration and detention. And we just have to be bold right now. And this variance, to me, doesn't feel bold. It feels like this is how we always respond to the situation. And I would strongly encourage the department, as the chief said, look at what other options you have available. Like, we all supported the technology to come in to reduce the violence that happens to officers, that happens to detained people. But the response to that technology can't be more isolation, more elimination of our minimum standards. It just can't be. And we have to be at a moment in time where we say, you know what? We have to be bold, we have to be visionary, and how do we use this technology in a way that's consistent with the humanity, consistent with the way that we see the way that New York is going to be leading on criminal justice reform? And so I would encourage the department to really go back and to think about ways that they can be bold with using this technology that doesn't rely on us doing a variance to our minimum standards.
Mr. Hernandez?
I also have a couple of questions. I'm very sympathetic, and I do believe that we are really at a crossroads of doing a lot of criminal justice reform, and that we should be, as I think we are doing, reducing mass incarceration and the like. On the other hand, I've been on the other side of this, where I've ran detention facilities where I agree with my colleague that the safety of people that are incarcerated and the people that work within the facilities is paramount, that you have to have a way of being able to ensure their safety in that environment. I just have a couple of very quick questions. One is that it sounds like you have, and I didn't get the proportion of people that are giving up contraband or surrendering contraband.
Yes, that number would be 22 individuals prior to a body scan surrendered contraband.
Which means that they don't go into a separation status.
They are not placed in separation status, yes.
Right. Right.
So, and that is 22 who surrendered after a positive image was shown they had contraband items secreted on their person or within their body cavity.
Correct.
Then there were 9 who were getting to be subject to the body scanner who surrendered prior to even having a positive image.
Okay. And then have had positive results from the scan. And what's the proportion of people that spend 3 days or 1 day or 2 days?
So the average day is 1 1/3 day.
1 in 30 days, okay. So
1 1/3, not 1 in 30.
1 1/3. I didn't say 30 days.
No,
I understood.
30 days.
Just 1 to 3 days. And
Yes.
The other point that I think I agree with both my colleagues is that there has to be a way somehow to integrate this into the broader process of looking at punitive segregation and solitary confinement and the like. So I would support that. But on the other hand, I am very supportive of a tool that's used by the department to be able to reduce violence within the city jails.
Dr. Cohn?
Yes, I wrote a letter in support of the body scanners. I endorse the use of the body scanners. Their value, I think, in terms of having people give up contraband and you identifying contraband is very important because it protects the staff of the department, it protects civilians, it protects people living in the jails. However, the variance request that you gave us was extremely disturbing to me. This was the second time that the department has given us a variance request. We had extensive discussions after the first one, and where we told you a number of things that we really needed to have in this variance request. And I'm disturbed that the City of New York Department of Correction would give us a variance request that says people can't have visits, can't see their lawyers, can't write letters, can't have recreation. I mean, it is, and I have to, Commissioner, you wrote to us, and we wrote to you and said, we want to have scanners, we want to develop a process to have it. And Interim Chair Sherman wrote a long letter proposing a whole bunch of things and describing why we wanted to come here. We wanted to come to a we wanted to support the scanners, but come to a process which respects the problems with what you had proposed. And the commissioner wrote back to Interim Chair Jackie Sherman that to prevent the concealment or disposal of dangerous contraband, separation status necessitates a reduction in several amenities required by the minimum standards. Visits are an amenity. Recreation is an amenity. Visiting your lawyer is an amenity. Maybe you didn't mean it, but you wrote it. And I want you to have these scanners. But I agree with Chief Perino, and I agree. I think the board probably all agrees that this is not the way to do it. 2B is a dungeon already, and you have created and put forward situations here which turn it into hell. It is not the Department of Correction that you want to be, and I think we should reject this. We have a whole bunch of conditions that you've accepted. They're not enough to make it into anything reasonable, and I really think you should come back to us next week when we meet again and give us something reasonable. The best thing would be something that is just as Chief Perino says, is something that just is a minimal variation on what our current solitary confinement regulations are. Not something which shouldn't be defended by the department, and the board should not be asked to countenance.
So, like on many occasions, I sit here in this board meeting, like I've sat in other board meetings, trying to figure out how to best balance competing concerns. And I, like many in the room, am concerned about our behaving in a way and engaging with detainees and with staff in the most humane ways. As I read this variance, what troubles me is that it seems as though we're going beyond what is necessary and we're engaging in practices that are intended to be punitive. I can't tell whether or not some of these restrictions are about safety or they're about, inflicting further harm to the mind. that's what concerns me with this. I cannot really get my head around, no visitation. I can't get my head around some of the the restrictions around recreation. I understand, no congregate religion to a certain extent, but it just seems like we're going a bit too far, and that troubles me. I understand the importance of safety. I understand the value add that the scanners are providing. But to just kind of dismiss some of the additional conditions that were presented with a general, no, it flies in the face of safety, without really leaning in and trying to figure out how we could do this in a way that ensures safety, but also doesn't take away some of the, the value add of these benefits, recreation, visitation. So I'm concerned about that. And at this particular point, with it as it's written, I don't see how we move forward.
I'd like to call the question.
I think based on the comments of my colleagues and the fact that we have scheduled a board meeting for next week, we will put the variance request, we'll table the variance request for today, and we will hope that we can engage in conversation between now and next week that takes into account what you've heard here today, both from board members and from members of the public who have spoken, and we look forward to working with you towards next week.
Thank you.
Thank you.
So with that, we'll move into our final public comment period, the public comment period on general topics. And we'll first call on Ms. V.
Hi, I know y'all probably tired of hearing me today, but so what? It's democracy. So I won't hold up too much time, but I might use more of my time. I just want to thank you for not pushing through today. I wish you would have voted it down, but I understand that you're walking into your conscience. And so I want to help you get totally into your conscience by next week so that you can properly vote it down. But I do acknowledge that most of y'all spoke up today, and I appreciate that, because many times a lot of y'all sit here mute. And I just want to say, as you think about the rule making, publish it today. Don't wait to the last minute. I know, Chair, it might be hard for you to decide how to put it out, when to put it out, but just do what's right. Do what you would want. I always tell people #want for others as you would want for yourself. And as you think about when to release that, do what's right. Release it today. We came here today to discuss rulemaking. Release it today in honor of Judge Hamill if you don't have any other reason. Do what your former peer on this board would want you to do. Walk in faith and understand that the advocates in the entire New York City will stand behind you. And truly understand what that means, because I just might be Ms. V to you, but I have so much power when it comes to doing what's right. The universe aligns with me. And Commissioner Brannon will soon learn that, because long before she came and long after she leaves, I will still be here. And the people of New York City will still be here. And we will acknowledge all of you who do what is right. And yes, as an Army brat, I totally understand safety. I used to live in a house with a drill sergeant, so I understand care, safety, and control. But I also understand humanity and standing up for the people of New York City and standing up for my neighbors and standing up for what is right. So one of the hardest things to do in life is to do what is right. But when you do it, you feel so much better, and you can sleep with pure understanding at night. And the universe and the creator, I don't know what you believe in, but if you do believe in a higher being, the universe will cover you when you walk in truth and you stand in your power. Stay blessed.
Thank you. Winston Huynh.
There's one more, I don't know why he's talking. I think one more person, he's this guy who, now he's back, he's going to talk about, I don't know, mail or something. He was on, this guy was on Rikers for 7 months.
Good morning.
Good morning.
This is not my Halloween costume. This is my prison uniform. And this is how I was released from Rikers back in May. I was released from court wearing this, with no Metro card, with no money, with no available ability to contact anyone that I needed. And what I did is I walked down and I sat at the Board of Corrections office with Martha, and I waited for someone to come and get me and bring me a Metro card. This is how I was released. I wear this today just to point out the fact that coming up very soon with the changes in cash bail, other people are going to be released from court, I assume, just like me. And I don't know what preparations have been made for them to come back to the communities. From small things like, for example, what do they do with their property if they're being released from court, right? Because my things were lost, never vouchered, and then I found them later in the garbage at the intake at OBCC because a friend of mine happened to work there and told me that. Or what about the, I saw all the CHS people left, so sadly they'll have to watch this on YouTube, but what about the Brad H. settlement requirements? It took me over 4 months to get psychiatric care, right, after I was. This is with resources, right? I'm a graduate of a Columbia University. I just graduated before I went to Rikers. It took me 4 months to get in to see a psychiatrist. So what I ended up doing is I went to my personal care provider and asked her to prescribe me what I was being prescribed at Rikers, and then I asked for my own blood tests. I had to do that myself. You're supposed to get a supply of medication when you leave Rikers, 7 days worth when you leave. I did not get that. Then you're supposed to get a prescription for 21 days of medication after that. I did not get that. I only got 14 days. I don't know why. No one seems to be able to answer those questions. But I bring all of these things up, not just for Brad H. and not just for my property, but just, I think Kayla said it earlier, it's all in the details, right? And it's little things like this. I don't know what preparations have been made for discharge planning. I assume that the outflux of people coming up in the next few months is going to be larger than usual, and I don't know that the department or the city is prepared for that. So that's my big question. And since I'm here and since I'm wearing these clothes, I will also point out that most of these things were given to me by the department, but again, not my shirt, and not these socks that I'm wearing, which were both given to me as an award, as a prize by FedCap, because these are, again, things that are not provided by the department. So I think with what we've all been talking about and with the plan to close Rikers, many people have expressed that it's a promise, right? It's a promise for whoever de Blasio's successor is and for city councils to come. But there are existing promises that are not being met, like our minimum standards or amenities or whatever you want to call them. Councilmember Levin said he wanted to propose new minimum standards. I agree with that, but I think we need to enforce our existing minimum standards. Otherwise, what's the point? And my council member is still here, so you saved me a phone call. But anyway, that's enough of my time. Thank you.
Thank you, Mr. Huynh. That concludes our public comment period, and that brings us to the adjournment of the meeting. I'd like to thank everyone who came today and who spoke, and to assure you that we've heard you, and we do look forward to engaging in the formal rulemaking process. We are reconvening on October 31st, and we'll publish the rule in advance of the meeting on October 31st. We will post the location and precise start time of our October 31st meeting on our website as soon as it is available. Thank you all.